Welcome to the Central Mind Podcast, and I'm your host, Tony DeVito, where we try and get to the middle ground of almost anything. None of the information provided in this episode should be construed as legal or medical advice. We at the Central Mind Podcast, our guests, affiliates, or any of their affiliates are not liable for any actions taken or decisions made by you from the information provided in this podcast. Please advise an attorney for any legal advice and a medical professional for any medical advice. We have a more detailed disclaimer available to you under the description of this episode. We're going to be speaking about the Florida ballot, and specifically Amendment 4 on the Florida ballot, which is in reference to abortion. And before we do that, we're going to go ahead and discuss what the current laws are in the state of Florida for abortion. Now, this episode is only to inform you of what the current laws are and what the language is on the amendment and what the definitions are within that language. I'm not here to tell you how to vote. I'm not going to even share my opinion on how I'm going to vote. I'm not going to make this a partisan conversation. It's going to be very bipartisan. It's going to just be the facts. Anything I don't understand myself, I will point that out. And there may be some additional questions brought to mind that you didn't have before you listened to this episode. So let's get on with it. One of the things I've noticed in the media recently, and when I say media, I mean pretty much any medium that you can find it on, whether it be social media or the legacy news, CNN, or MSNBC, or pretty much anywhere else that provides news, as well as commercials during football games and YouTube commercials, anywhere you can stream video or audio even. There have been some commercials out there misleading the public about what Amendment 4 will do. These misleading commercials will tell you that there's an outright abortion ban in the state of Florida or an extreme abortion ban, and that the abortion ban is so detrimental and so restricting that a woman whose life is in danger would have to either A, go to another state that allows abortions with less restrictions, or B, could possibly risk their life and potentially die because the state of Florida's abortion ban is so restrictive that it doesn't even help them protect themselves from a life-threatening event. So I will tell you that is not true, and current Florida law does contain some exceptions. Before we get into these exceptions, I also do want to mention another misleading piece of information that's been going on commercials in the opposite end of the spectrum. So those previous ones that I mentioned are trying to manipulate you to vote yes on 4. Now there are also other ones that are trying to get you to vote no on 4, such as parental consent for minors that are pregnant, and whether or not it's required for them to get consent of a parent before they get an abortion as a minor. We're going to talk about that later in the podcast, but I do want to let you know that there are both sides of the coin here where you're getting misleading information from both sides, the side that wants you to vote yes and the side that wants you to vote no. So let's get into it. Currently, the law is that a woman cannot get an abortion past 6 weeks of pregnancy. 6 weeks and 0 days, actually. And yes, that may seem extreme or to be an outright ban on its face, because most women don't know that they're even pregnant until 6 weeks. So it's not a reasonable restriction, so to speak, given that a woman doesn't even really know that she's pregnant until the 6 week mark or after, which essentially makes this a no abortion law. However, there are some caveats. There are some exceptions to this law, and that is to save the pregnant person's life, to prevent serious risk of the pregnant person's physical health, if the fetus is not expected to survive the pregnancy, and if the pregnancy is a result of rape, incest, or human trafficking. So just in the first few things that I mentioned there already debunks what those commercials are telling you. The commercials that are saying a woman had cancer, brain cancer, and she needed to get the brain cancer treated, but while she was pregnant couldn't do that and needed an abortion in order to do that. And if she didn't get the abortion, she'd be dead today if this happened to her right now with the laws the way they are in Florida. And that's just not true. The current law does allow for a person in that circumstance to get the abortion, continue with the treatment for the cancer or whatever other life-threatening illness or situation it may be, and there'll be no laws or penalties to stop that individual, to prohibit them or delay it. So that commercial and commercials like that are just not true, and they're fear-mongering to get what they want. I don't want anybody to vote to fear-mongering. Don't make a decision on the ballot because you're afraid. Make a decision on the ballot because you're informed. So that's what I'm hoping to do here. I'm hoping to inform you. Now, if you're in agreement with the current law, which is 6 weeks and 0 days, that anything past that, you can't get an abortion unless it's those exceptions that we mentioned. Keep in mind, though, the exception of rape, incest, or human trafficking only extends out to 15 weeks in the current law. So that means if you are pregnant because you've been raped or because you're in a situation where you're a minor, you're 15 years old and there was some sort of incest going on and within the family and you became pregnant, or you were human trafficked, meaning you were used as a prostitute, and you become pregnant from any of these things, you only have until you're 15 weeks pregnant in the state of Florida to make the decision and get an abortion. Now, I think that seems unreasonable. The reason I believe that to be unreasonable is, what if a woman who's been raped or impregnated through human trafficking or incest is not able to free herself of that circumstance until after the 15 weeks of pregnancy? What if she's 4 months pregnant and she's just now able to escape that situation to where now she's safe enough to go and get an abortion? Should she still be held to the pregnancy? Should she have to carry a child that was conceived through rape or prostitution, forced prostitution, or incest? I think that they're missing the mark on the current law. That's my opinion. I think they could take that further. I don't think that it's right to hold a woman to 15 weeks for those particular issues, those circumstances, because not all women can escape those circumstances so that they can safely make that individual free decision, and they may still be under threat, even after 15 weeks. So I feel as though that could be dealt with better, and maybe this new amendment will resolve that. So let's see. Let's read the language and see what that says. It says the current Amendment 4 for the state of Florida is, no law shall prohibit, penalize, delay, or restrict abortion before viability or when necessary to protect the patient's health as determined by the patient's healthcare provider. Okay, so what does that mean? Well, it means it's pretty straightforward, I think, that Florida cannot create a law to prohibit or penalize or delay or restrict a woman from getting an abortion before the fetus is viable. And what does that mean? What does viability mean in Florida's definition? Well, in the Florida law, viability is defined by a stage of fetal development when the life of the fetus is sustainable outside of the womb through standard medical measures. I'm sure standard medical measures are pretty well defined in practice, in common practice in the state of Florida, of what occurs after a child is born, after viability, and also there is some, I think, mostly an agreement on what viability is, usually around the 24-week mark, maybe 26 weeks, depending on the pregnancy, which is around 6 months. So this law would essentially allow a woman to get an abortion. It would change that 6 weeks and 0 days to about 6 months. And then after that, basically a woman would not be able to get an abortion unless, when necessary to protect the patient's health, as determined by the patient's healthcare provider. Okay, so one of the things is patient's health. What does that mean? There's some argument about whether or not that means the patient's mental health, the patient is just having aches and pains and just wants to get the abortion after the 6 month, or the viability. We're going to call it 6 months because that's about viability. The patient just wants to, abort the pregnancy because of it. They feel unhealthy, and they found a doctor that was able to agree that, yes, you're not healthy because of your pregnancy, and it may just be what any other woman would consider a standard issue during pregnancy. That's what some people are afraid of, that people will stretch that patient's health definition. I'm sure that may happen in some circumstances, but I'm sure it'll get litigated heavily, and it'll probably become more defined as time goes on. And sure, that means that the state will have to pay more money for this issue, and there will have to be some fights in the courts to find a more restrictive language or definition to what patient's health means. Therefore, the new amendment on the ballot, Amendment 4, would allow for the patient to go ahead and get that abortion past the date of viability for the fetus, as long as the patient's health is at risk, and that would be determined by their physician, their healthcare provider. Actually, it says patient's healthcare provider. And one of the things that people are also arguing about, one of the other things, is what they mean by healthcare provider. And that's a fair question, but Florida law already defines who can perform abortions in the state of Florida. So I'm not really seeing where the argument would be for that. But again, I'm not a lawyer, I'm not an attorney. So some of these things can be argued in ways that you or I are just not able to even conceive of. So some of these things could be construed differently in the courtroom than the way you and I can right now, just talking about this on a podcast or reading it at the ballot box. And that's unfortunate, because these things really should be defined better, but I understand why definitions lack when putting things on a ballot. Things change through time. The cultural definitions of a term, phrase, or word could change over time as well. Culturally accepted things of today may not be culturally accepted 15 years from now. So the more broad the law, the better for those sort of circumstances. Otherwise, we'd be relitigating issues, not even big issues like this, but small issues, time and time and time again, which becomes costly and draining and overly restrictive. So I understand why language is broad on ballots. I'm just not a big fan of something as important as this being as broad as it is. But let's go through the current law for a minute again. I actually want to talk about what it is. It's actually in the Florida statute. It's Chapter 390, and under termination of pregnancies, which is 390.0111, it says termination after gestational age of 6 weeks. When allowed, a physician may not knowingly perform or induce termination of pregnancy if the physician determines the gestational age of the fetus is more than 6 weeks unless one of the following conditions is met. So again, we just went over that, hey, the current law in Florida, you can get an abortion up to 6 weeks and 0 days. Anything over that, you're not able to, unless, and here are the exceptions. 2 physicians certify in writing that in reasonable medical judgment, the termination of the pregnancy is necessary to save the pregnant woman's life or avert a serious risk or substantial or irreversible physical impairment of a major bodily function of the pregnant woman other than a psychological condition. All right, so one of the exceptions to the 6 weeks is that 2 physicians decide that the pregnancy needs to be terminated in order to save the woman's life, the pregnant woman's life, or avert a serious risk of substantial and irreversible physical impairment of a major bodily function. Now, it does not include a psychological condition, so you cannot get an abortion in the state of Florida past the 6 weeks for a psychological condition. So let's move on to the second part, which is 390.0111, paragraph 1, subparagraph B. The physician certifies that in writing, in reasonable medical judgment, there is a medical necessity for legitimate emergency medical procedures for a termination of the pregnancy to save the pregnant woman's life or avert a serious risk of imminent, substantial, irreversible physical impairment of a bodily function of the pregnant woman other than a physical condition, and another physician is not available for consultation. So the Part A had said that 2 physicians needed to certify it in writing, but in this case, if there are not 2 physicians available, if it's an emergency and it must be done now, the physician can go ahead and perform the abortion without the second physician consultation. So Part C, the pregnancy has not progressed to the 3rd trimester and 2 physicians certify in writing that in reasonable medical judgment, the fetus has a fatal fetal abnormality. So in this part, it's past, we're now even into the 3rd trimester, and they realized that the fetus would not be birthed alive. So at this point, 2 physicians can certify that the fetus can be aborted since it will not be a live pregnancy. And the next part, D, the pregnancy is the result of rape, incest, or human trafficking, and the gestational age of the fetus is not more than 15 weeks as determined by the physician. At the time the woman schedules or arrives for her appointment to obtain the abortion, she must provide a copy of a restraining order, police report, medical record, or other court order documentation providing evidence that she is obtaining the termination of a pregnancy because she is a victim of rape, incest, or human trafficking. If the woman is 18 years of age or older, the physician must report any known or suspected human trafficking to a local law enforcement agency. If the woman is a minor, the physician must report the incident of rape, incest, or human trafficking to the Central Abuse Hotline as required by Section 39.201. So this is what we spoke about earlier, where a woman can, in the state of Florida, get an abortion if it was a result of rape, incest, or human trafficking. However, it's restricted to the 15th week. Past 15th week, that would not be allowed still. The woman would still have to go through with the pregnancy after 15 weeks. Also, you can't just go and say that you've been raped or were forced into prostitution or there was incest and this is why you're pregnant and you want to get an abortion. You have to have some sort of documentation from the state from the court stating that this is your circumstance and that you're approved to get an abortion past the 6 weeks, but not after the 15. And the new Amendment 4 would change that 15-week situation, at least to 24. Now, the new amendment on the ballot, Amendment 4, does not mention anything about what would happen after viability. Can you still accept for the exception of the life of the mother? But what about rape, incest, or human trafficking? I'm assuming, because it's not listed on the ballot on Amendment 4, that it would still be restricted within that before viability circumstance, meaning that you'd still be able to get your abortion if it's for any reason. It doesn't matter if it's rape, incest, or human trafficking. Even if you just want it because you decided, I'm not going to be able to afford this financially, I'm not emotionally stable enough right now in my life, or the other relationships I have in my life don't make this sustainable for me. I am not in a position to where I have the proper and appropriate support from others to raise a child, and I'm by myself. So maybe these are the decisions that you might come to, and you have the first about 24 weeks to 26 weeks to do that with the new law. Don't go by me with weeks. I'm just stating what is common knowledge among the medical field when it comes to what they consider to be viability for a fetus, and it's around 24 weeks. So if you vote yes, and 60% of the population of Florida, the voting population of Florida, votes yes on 4, then it gets extended from 6 weeks to about 24 weeks, meaning viability about 24 weeks, and it's for any reason whatsoever. But after that 24 weeks, the new amendment, Amendment 4, only states to save the life of the mother for the mother's health. It doesn't even say to save the life of the mother. It says the mother's health, the patient's health. So, but it doesn't define what health means there, whether it's mental health, emotional health, physical health. How extreme does that health risk have to be? It didn't define any of that. I'm sure that will get litigated if it gets passed. But those are the current exceptions, and I wanted to read them for you because I'm sure none of you, or hardly any of you, have gone on to the Florida site to read the current statute and what laws are currently in place before you go and vote. So, in-person performance, this is the next paragraph in the Florida law, and it says in-person performance by a physician required. Only a physician may perform or induce a termination of pregnancy. A physician may not use telehealth as defined in section 456.47 to perform an abortion, including but not limited to medical abortions. Any medications intended for use in a medical abortion must be dispensed in person by a physician and may not be dispensed through the United States Postal Service or by any other courier or shipping service. So what does this mean? This means that we talked about what does healthcare provider mean, right? In the new amendment, when they say that the abortion must be done by the individual's healthcare provider. Well, this defines what that is. You don't need to redefine it. It already is in law. That would not replace this part of the law, is my understanding. Now, again, I'm not a lawyer, so I'm sure somebody will want to try and argue this, but there is a common agreement and understanding of who is allowed to do abortions, what a physician is in the state of Florida. It's here. It's already defined in the law that only a physician may perform or induce a termination of pregnancy. So I don't know that the health provider language in the new Amendment 4 on the ballot is something that should be argued, but I'm sure somebody will. I can't imagine that somebody wouldn't. So I do want to go down to paragraph 3, part B of the law. I want to read this. If a medical emergency exists and a physician cannot comply with the requirements for informed consent, a physician may terminate a pregnancy if he or she has obtained at least one corroborative medical opinion attesting to the medical necessity for emergency medical procedures and to the fact that, to a reasonable degree of medical certainty, the continuation of the pregnancy would threaten the life of the pregnant woman. If a second physician is not available for a collaborating opinion, the physician may proceed but shall document reasons for the medical necessity with the patient's medical records. So essentially, this would also approve a physician to go ahead and perform an abortion past the 6 weeks, that current 6 weeks, and if it's a medical emergency and saves the life of the mother, and it doesn't require that two physicians are present or that two physicians corroborate the opinion that it's a necessity. This is, again, emergency medical circumstance, and a woman would not have to basically sentence herself to death because it's past 6 weeks and she has a medical emergency and she's going to die if she doesn't get the abortion, and there's only one doctor available. So that's not a concern. Currently, the law states that if there's only one doctor available, then that's fine. The doctor just needs to document the reasons for the medical necessity of the patients in the patient's records for why they performed an emergency abortion. And Chapter 4 is standard of medical care to be used in the third trimester. If a termination of a pregnancy is performed in the third trimester, the physician performing the termination of pregnancy must exercise the same degree of professional skill, care, and diligence to preserve the life and health of the fetus, which the physician would be required to exercise in order to preserve the life and health of the fetus intended to be born and not aborted. However, if preserving the life and health of the fetus conflicts with preserving the life and health of the pregnant woman, the physician must consider preserving the woman's life and health and overriding and superior concern. So that basically means that third trimester abortions are very frowned upon in the state of Florida. And if the physician has to perform a third trimester abortion, he or she must do so with great care to preserve the life and health of the fetus. Now, they do still list the exception here that if the preserving the life of the fetus were to cause great physical harm to the mother or risk the mother's life, then the doctor can proceed with a full-on abortion that would no longer preserve the life and health of the fetus. So what does that mean? That means that even in the third trimester, if they can't save the life of the fetus because it's too risky for the woman, then they'll go ahead and abort the fetus without the intent to save the fetus's life. In also the next paragraph is partial birth abortion prohibited, but there's an exception. No physician shall knowingly perform a partial birth abortion. A woman upon whom a partial birth abortion is performed may not be prosecuted under this section for a conspiracy to violate the provisions of this section. This subsection shall not apply to a partial birth abortion that is necessary to save the life of a mother whose life is endangered by a physical disorder, illness, or injury, provided that no other medical procedure would suffice for that purpose. So again, this is just yet another exception to one of the abortion procedures, that if a woman's life is in risk, then they allow the abortion to take place. The question is whether or not some or all of these exceptions will remain in place, these definitions of what exceptions are, if the new amendment gets passed, if it's voted in by the public, by the voting public of Florida, or would it be replaced by the simple language of the patient's health? So I think that's what a lot of people are concerned about, and honestly, I don't know the answer to that. I don't know how much of the weeds here gets kept and how much of it gets tossed and replaced with the simple language of the patient's health. If it gets replaced with just that simple language of the patient's health and and it does not maintain all of these exceptions and the language that's currently here, then I can see that there'll be a lot of future litigation for this circumstance, for this particular law. But that's going to have to be up to you as the voter to make that determination of whether or not You're comfortable with that? Let's talk about parental consent, because this is a big one, and I should have brought this up earlier, but I didn't, so here we are, and let's get started on it. Currently, the law in the state of Florida for parental consent for an abortion is that it's required. This current amendment on the ballot, Amendment 4, does not change that law at all. So parental consent is still required by the state of Florida for an abortion. There are some commercials out there that are stating that if Amendment 4 gets passed, then your minor child can go ahead and get an abortion without your knowledge or consent, and that's why you should vote no on Amendment 4. That's not true. That is very misleading. It could be beyond misleading, just be considered an outright lie, but it's not true. It doesn't change the current consent laws for minors. So as written in Chapter 390.01114, and this is parental notice of and consent for abortion act. And there's some definitions here, but we're going to jump ahead to paragraph 5, subsection A, which says a physician must obtain written consent from a parent or legal guardian before performing or inducing the termination of a pregnancy of a minor. So your child under the age of 18, if she gets pregnant, before she can get an abortion, if that's what she wants to do, the parent must be notified and the parent must give consent, the child's parent. So I wouldn't be concerned about that one. I'd be more concerned that your daughter got pregnant, but not concerned about whether or not the state is going to allow an abortion without consent, because it won't. So I think for me, my understanding is that current law has some pretty good exceptions for the state of Florida to protect a woman's health, to protect her life. I think that there's some fairness in the exceptions when it comes to rape, incest, and human trafficking, though I believe that because they're victims that may not have the circumstances to allow them the ability to make this decision of their own free will by that 15th week. I really feel like that is a shortcoming in the current law. I also feel like for women who want to get an abortion for no other reason than they just want an abortion because they don't want children, or because their lifestyle does not support what's best for a child. Maybe they don't make enough money. Maybe they live in a really terrible situation, an abusive situation. Maybe they are not emotionally or physically able to do it. Maybe they're just not ready, and they don't have the support system in place. So if a woman wants to do that, it's currently 6 weeks. That's your restriction. So as a woman, if you want to make that restriction past the 6 weeks, if you want to extend that out to viability of the fetus, then this would be your time to vote yes. And if you're somebody who's against it and think the law should remain the way it is now, or you even believe that it should be more restrictive, then you would want to vote no on this current amendment, Amendment 4 on the Florida ballot. But that's your choice. I'm not going to tell you which way I'm going to go. I just hope that I provided you with some good information. Just vote your conscience. Just do at the voting ballot what you think is right for this particular amendment, for this particular law, and that's the best you can do. You have the information now. Some of it created some additional questions, but you can go out there now and you can make a more informed decision than you would have had you not listened to our episode today. Be sure to still do your own due diligence. Go ahead and go on to the Florida website. Take a look at what the laws are. Read the current laws for yourself, the current statutes. Don't take my word for it. You just have to go to leg.state.fl.us. That would be LEG, short for legislator. leg.state.fl.us /statutes. That will get you at least in the right direction, you can start searching for the statutes. You could also do a quick Google search, but make sure you go to any Google search results that brings you to the official Florida legislator's website, which is the link I just provided. That's where you want to look at this information. You don't want to just look at it anywhere. You're going to get a lot of false information that way, not because everybody's trying to lie to you, but because people don't understand it. They don't understand the law. They don't understand what exactly the new amendment means. And as we discussed, we don't know what the new amendment will mean exactly either. But at least if you read what the current laws are and the current definitions of the laws, it'll help you better understand. It'll help you make a better decision. Be sure to hit that follow or subscribe button to continue following us and listening to our podcasts. I promise we'll get better and more interesting with each episode. Thank you for listening in with the Central Mind podcast. This was our first episode, and I really enjoyed doing this with you guys. My name's Tony DeVito, and we'll see you next time.